Amen. Amen. It's good to see everybody tonight. Let's open up in prayer and we'll get started. Father God, we love you so very much. We're so grateful for life, health, and strength. Lord, we live in a time when our community is changing, our governments are changing, even with decisions as recently as today. God, families are being impacted by the law. And we're grateful, Lord, for men and women who believe in Jesus Christ, God, who love you, but you've called them to serve you in the area of law. We're grateful tonight that you've given us a safe place to have this discussion and to share information, Lord. And so we ask that your Spirit would be in our midst and guide us tonight, and that some would be helped, some questions might be answered, some confusion might be cleared up, so that we might live our lives in a way that's honoring and pleasing to you. God, we love you. Thank you for those who are listening on the live stream and those who are on their way. We trust you and we praise you. It's in Jesus' name that we pray. Amen. All right, everybody. It's good to see you tonight. I'm very honored and excited to have my brother in Christ, Mr. Ted Ogilvie of the Ogilvie Law Office in Frisco. Ted is one of, I could almost say this fivesome, but the four of my friends that are coming tonight, he, like them, was among the first that I met when I began practicing here in Denton County, and he has been a lifelong friend. He's a believer in Jesus Christ. He has a wonderful family, and I'm just grateful to have him tonight to be with us, to share some time. Ted is a Texas A&M Law School grad, and he's a former executive board member of NCTC and the Denton County Bar Association. He's a member of the College of the State Bar of Texas. He's been selected to the 10 best attorneys in 2017 and 2018 for client satisfaction in the American Institute of Family Law Attorneys. I can't say enough about this brother. We're grateful to have him tonight. And so if you would, clap your hands for Mr. Ted Ogilvie, and I'll yield to him.
Thank you. Thank you very much. And would you please rise? Dearly beloved, you may be seated. Kind of a corny way to get into this, but one of the things that is striking about my topic, family law, is that it stems from cultural and from probably as long as we have existed, from Adam and Eve to now, in different ways, but we think of weddings, we think of marriage, we think of those things generally, and then flows down from that family and children and all those things that go along with that. That pretty much is what our laws are based on, and that's how we're going to kind of approach that tonight. I really appreciate you letting me speak tonight. Brother Chris has been a friend of mine for a long time, and I'm grateful to have him as a friend. I'm grateful to have him as a sounding board, someone who is who knows what I go through on a daily basis, and then still has reason and says, Ted, that ain't right. Or you're on the right track, just keep with it. To have good counsel like that. So I'm very, very thankful for Chris and his friendship, Charmaine, and the friends that I've met through Chris. So thank you. So let's kind of begin. There's at most weddings, you're going to hear something about love. L-O-V-E, love. Exactly. And that's one of the things that, even in Scripture, the most talked about at weddings is 1 Corinthians 13, the love chapter, right? Well, it starts out, 1 Corinthians 13 starts out with, well, if I have a prophecy and I prophesy, and I have faith, but if I don't have love, then I'm just a clanging cymbal. And it goes on a couple of times to say, if I have these things, these good gifts, these good works, these good things that I do, and I don't have love, then I'm nothing. And I want you to conceptualize that, because I really think that that's where we are with in cultural issues here in the state of Texas. I'm going to go through this a little bit. But when the love stops, the only thing you have left then is the law. That's what they had in Judaism. So there were many laws in the book for how to approach weddings, what to do if someone had infidelity or had other issues. Through Roman law, through Jesus' time, if we look back a little over 2,000 years ago, there were certainly issues with marriage. And if you take out the love, then all you have left is the law that goes along with it. And it's just the law. And if you think about what our Lord's commandments were, I came to fulfill the law, but I leave with you 2 commandments, the greater commandments, right? Love your God with all your heart. Love your neighbor as yourself. And if you take those things out of it, you're left with the law. So that's what I deal with on a daily basis, is the law. Because many people come to me, what can I do about this? He or she has wronged me, has done this. And, well, what can I do about it? Well, I don't know. Have you lost the love too? What is it you want to do? Do you want to just go by the book? Or do we need to go back to the book? Every day I challenge people when they come in to talk to me, and I consult with them. How do you want to approach this? And at the end of this, I'm going to try to approach it. I'm going to give you some of the approaches that I use and really like to use instead of just going to court. I've been in court a lot. I don't like going to court. Well, let me rephrase it. I'm a lawyer, so I love going to court because I love hearing myself talk. And I love coming out of there. See, I told you we'd get that, right? Yeah, we got it, and everybody's happy. But I got to tell you, more times than not, that means over 50% of the time, people are coming out of court and they're not happy. That's my clients. Over 50% of the time we go to court, they're still coming out not happy, even if you get everything that you asked for. One time I had a trial and I represented the wife, and yes, the man had done some things, had an illegitimate child, was going to be having a child with this lady. He was leaving her and his 2 kids to go get married. Boy, that's just not right, is it? I mean, here we're in a court and they were church folk, right? But they lost the love. So the only thing they could rely on, and they hated each other. Couldn't get them back. In the trial, I got her everything that I could possibly get per the law, and more. The judge was on our side, right? Because she clearly didn't like what this guy had done. And it just seemed like an abomination that he could go do that, marry somebody 10 years younger, have another kid, start a new family, and then just leave these. You know, he gets to take it. No, he didn't get to take everything. We got more than 50% of the estate. We got a lot more. Got more time with the kids, if that's a blessing or not. I don't know. You know, we're taking time away from parents. So it's the law. Doesn't have anything to do with love, right? It's the law. I got her everything. We come out, and she's still not happy. His head wasn't on a silver platter. That's what she wanted. So, we're going to look at the law a little bit tonight. We're going to start with marriage. Okay, this is going to be our little framework. I know it's kind of hard to see, and I'm going to be zooming in on some of these things a little bit. But marriage is where fundamentally we start, even with our Texas Family Code. So in the state of Texas, and every state has its own laws. And every state may have some differences in its own laws. Some states may allow you to get married younger than in other states. Some states may allow you to marry your cousin, and other states may not. Other things, you know, there are peculiarities about marriage. And so every state has its own code, its own laws. So in the state of Texas, we have the Texas Family Code. And we're going to get into that a little bit. We also have case law. So as that code goes to court and is challenged, then different cases come up that interpret how that code is applied. Okay, so it's kind of an ever-moving target because you know, at some point a really clear area of law might get challenged, and an opinion might come down that changes the way it affects. Let me give you an example. Grandparents, for the most part, have never had standing to step into a case in Denton County. Why? Because Denton County is part of the Second Court of Appeals, which is out of Fort Worth, and that takes Tarrant County, Denton County, Cook County, and a few, Montague County, and those counties that are kind of west of there, right? But if you go to Dallas, and the Dallas Court of Appeals has Collin County, Fannin County, Grayson, and that Court of Appeals allowed grandparents' rights. They interpreted some of those things differently. So that's just an example. Even in the state of Texas, even within our counties, there might be peculiarities in each county's laws. So whatever jurisdiction we're in. So, under marriage, unless you've been living under a rock over the last few years, we've had some real challenges to what is a marriage. A marriage traditionally has always been a man and a woman with a union together. That would be legal. And that's where the family code stops. When we're looking at the church, generally we're looking at that it's kind of a contract between God. I've always used this and always loved this. When I got married to my wife, there's the husband, there's the wife that are going to have a contract between each other. They also have the contract between God. It's a triangular contract. You can't get out of it this way. Can't get out of it this way. Unless you're going to do it, unless you're just going to give up on everything. So it's I've always liked that. The Texas Family Code, well, that's based on love though, right? Because God is love, and we have that contract with God. We have that promise from God. Does this woman take this man? Does this man take this woman? And we believe that. I believe it. But we're dealing with the code with a lot of non-believers, or people who kind of believe and kind of don't. So we put together all these things in Austin. And then not only in Austin, but then the Supreme Court and other things 4 years ago, there was case law. There was a case out of Texas that went up to the Supreme Court. It was the case of Oberfeld that did allow, Supreme Court said, well, there's no reason then why our laws should discriminate, so same-sex couples should be able to marry. And I'm not going to get into too much more of that, so don't worry. Right now, and if you ever want to talk about that, we can. But that's the family code. Marriage now involves involves two people. So you can think of it as a domestic partnership, whatever. A lot of people now elect not to be married, and we're going to get to that here in just a bit. But marriage is the union of a man and a woman, and that's it. How do you get out of a marriage? Backing up to the marriage, usually we think of, if you're going into a marriage, then you're going to be having kids. We can't wait for the kids to roll around, and grandma and grandpa are waiting for you to have kids. So that traditional thing. We have a lot of non-traditional families now. We have a lot of non-traditional marriages, a lot of non-traditional children being born, not necessarily in a marriage situation. But let's just think of, in a marriage, we have people who don't get along and they lose the love. What do? A lot of people think, can I just get an annulment? An annulment rarely occurs in the state of Texas, because really Texas doesn't allow, you're either married or you're not in Texas. And the only way to get not married is by a divorce, with the exception of a couple of little things that would allow you to get an annulment. If there was some illegality, somebody trapped you in by fraud or whatever it is, then you would be able to say, hey, I'm going to get an annulment. And believe it or not, fraud happens these days, and we know it even by the phone calls that we get, right, from Sierra Leone and wherever else, saying, oh, call me back and we're going to charge you $20. So fraud is all around us, and that leads to bad marriages. So you have to act very quickly, by a matter of days, just a couple of days, and you might be able to get an annulment. And most people don't act within that time. Interestingly enough, a lot of people, when they get married and say, oh man, I shouldn't have done that, I know it, I shouldn't have done it, they wait, and they wait. And they're an ostrich, and they stick their head in the sand, and they wait, and it just never gets any better. So, most of the time it's by divorce. Divorce just is simply dissolution of the marriage. But if only it were that simple. By the time we have children, by the time we have bought the car, by the time we bought the house, or we went down to Rent-A-Center and put a contract in, and we have all the good stuff in our house now that we're paying on, and now we want to get a divorce. Well, who gets stuck with what? Okay. So in a divorce, there really are three things. The first one is, it's going to be the dissolution of the marriage. And that's either by some reason, by fault, no fault, or it could be criminal stuff. Okay? The other part is, the second part rather, is going to be the division of your property and debts. The third part is the division of your children. Sounds kind of crude, but it doesn't have any love in it. Okay, we're already to the law, so it's really the division of children. It's the division of time, it's the division of money, it's the division of rights, it's the division of duties and responsibilities. So, let's go to the division of fault. In the state of Texas, and most states now, have a no fault, okay? Most of the time, we don't see any fault. You can plead for a divorce, and there's no fault. Just, you don't get along anymore. It's that you disagree with each other. You just have no meetings of the minds, and you're not going to have any more. It's done. So, Judge, I want a divorce. Okay. There's no question about what did he do, what did she do. Have y'all tried to fix this? There are some states. There are some states that have waiting periods, and there are some states that have obligations for you to do, some hoops to go through before you can get a divorce. Some states have a year waiting period. Louisiana is one of those. It generally has, if you have children, it involves a year waiting period. There are some states then that not have I believe they're, one of the Carolinas or one of the states in the Southeast has a 3-year waiting period. That you can't get a divorce for 3 years. It's almost like a punishment if you're there. But then again, the love is out of it, so you might as well be punished, right? So that's what the state is saying. Because we're always walking this fine line of culture versus law versus religion. And who knows where that is. So some states say, we're going to punish you. This is more of a punishment. We're going to put that in the law, that's what it's going to be. Texas, we have a 60-day waiting period. If you wanted a divorce, you have to wait 60 days. On the 61st day, if you both agree that you're going to get a divorce and everything's taken care of, then you can get a divorce on the 61st day. So we do have a 60-day waiting period. Don't really know why that exists so much, except that it keeps people from just doing it willy-nilly. It does slow it down a little bit. We still have what's called due process of law, which means you can't get a divorce on your own. Both people are going to have to appear to get a divorce. Or if you want a divorce, you're going to have to show the court that you tried reaching out, that you tried to find your spouse, and show the court that you couldn't find them. So they're going to give you what's called a default. They're going to grant that divorce by default. No fault. You could have some indiscretion, and that's what usually leads people there, is that, well, somebody cheated on me. My spouse, my wife cheated on me, so that's why I'm here. My husband ran off with someone else. These things happen, and it's sad. I'm not here tonight to preach. I'm really just here to tell you about how we deal with the law of families in the state of Texas. Believe me, I try to preach enough to my clients when they come in. One of the things I always ask my clients, do you go to church? Do you have a pastor? If you don't, I'll find one for you to talk to. All lawyers don't do that. Matter of fact, there are a lot of lawyers who, it is a money business. It is a money business. That's what puts food on the table for my household. That's what puts clothes on the back. That's how I make money. But I don't take that lightly. And then there are some that's criminal, and we can get into that a little bit more when we get to children, but if you think about abuse, and you think about all the things that are coming out now that we're seeing more now than what we did, particularly 50 or 60 years ago. It's amazing what we're seeing out there. And I'm not going to get on a Me Too soapbox, I'm not going to get on whatever, but there are a lot of physical things going on between humans that shouldn't, in the terms of violence. Whether it's hitting, whether it's trying to romance somebody and you're not getting consent, but you do it anyway. So there can be some criminality there that could lead to this. So a court, if you're in court, a judge is going to consider whether or not, was there any criminality there? Or was it just indiscretion, and judges really don't care about the fault of the breakup unless it's criminal? Or is there just no fault, which is kind of in the middle anyway? If there has been something criminal, then judges usually hold that against the spouse that committed the crime. So if you've been convicted of or if you've pled guilty or convicted of family violence, hitting someone, then that really goes against you, and the court can use that against you in awarding time and money and whatever else out of your marital estate. Yes, ma'am?
So if someone was accused of a crime, so not against their spouse, but someone else, would the spouse be able to file for divorce even if that person had not been convicted, only accused? I mean, do you have to actually go through the process of being, convicted in order for the judge to say, well, yes, you have criminal
Well,
freedom?
that's a good question. So let's think, number one, you don't have to have any fault to file for divorce. So yes, you could file. And you could allege that that person did certain things and that's why you're wanting out of the marriage. Whether the judge has to accept that or not, in terms of evidence, and that's kind of an evidentiary question, and if you didn't hear what she asked, it was a question of, if your spouse has done something but they haven't been convicted of it, but you know or you think that they did that, and that's why you're wanting the divorce, can the court use that against that person? And the answer is, if there's evidence that comes in to the divorce trial, then the judge can believe that or not. The judge doesn't necessarily have to have a conviction from someplace else, from another court, to say that he or she did that. You can sometimes put evidence on about that. But there is a general rule that you can't use a criminal accusation against someone and just let it stand as that. It would have to have been an actual conviction. And then generally we have a 10-year period of that. If it's over 10 years, if it's over 10 years, then you can't use anything that's been over 10 years. That's a crime from a conviction. So the second part of the division of coming out of a divorce is the division of property. And this is, I think, so I am following Jennifer Ramos and then Her Royal Highness Theta Page from last week. So, and I'll just give you a little bit of a background here. I say that I love Theta, and if you know Theta, she and I used to office. I used to live just here in Oakmont many years ago, and then my office was on right across from Bill Utter Ford, the building with the blue roof, when Jerry Garut practiced in there, and my office was on the second floor. And Theta Page and I office shared for several years. But I've had an office in Denton County and in Denton and Louisville for about 15, 17 years. 2 years ago, I did put an office in Frisco, so it's closer to my house now since we moved to Frisco about 4 years ago. But the division of property, we have a community property state. And I think you probably heard that either last week or maybe the week before with Ms. Ramos, with Jennifer, who probably talked about probate and wills and stuff like that. Well, the idea, does anyone know what community property is? What it really means? Yes, ma'am?
Property acquired during the marriage?
It is. It's the property acquired during the marriage. And what that means is that each spouse gets 50%, but it's undivided. So if we were married, then we got this chair, and that's the only thing that we have. We have this chair, then it's 50% mine, 50% yours. And we're going to fight over it, right? People do. How do you split the chair? Saw? There is no way to split some things. That's why it's called an undivided 50%. Sometimes we just have to put a value on it and say it's worth $10. So I'm going to have to come up with $5. And I'm going to get, if we have $10 over here and we have the chair, then I'm going to get $10 and you get the chair. Okay? So that's the division of property. The same thing with debts. Who acquired the debt? Last week I know you talked about forgiveness in debt and bankruptcy and things that come along with that. Well, our court that is going to have your divorce trial isn't really concerned about the bankruptcy so much. They're just going to look at what you have, your assets, your debts, your credit cards, your mortgage, everything else that you have, your car note, the rent-a-center payment, whatever it is that we have over here, it's going to look at that and going to divide that up. Whatever, if the TV is on the rent-a-center and you take the TV, then you're going to take the debt too. Okay. That's generally how it works. But it's usually a 50-50. We're a community property state. Not every state is a community property state. As a matter of fact, probably more states are not in the United States community property states. So, how do you divide things? Well, you put on evidence and you can have a jury decide who gets what, or you can have the judge decide who gets what. If I had $1 million and I went into the marriage and that's all we had, we got a divorce 10 days later, that $1 million was still mine. Unless, of course, during the marriage I gifted it to my wife. If I gifted it, well, that changes it. Then that's hers. Or if I even gifted her a half of that, well, then it's half hers and half mine. But if I had the $1 million before I went into the marriage, it's still my $1 million, unless I give it away, either to her or someone else. So the other issue there is mixed property, because sometimes, well, I'd have $1 million there, and then let's say that we do really well, and she came in with $2 million. And now we have $3 million, but really not. She has $2 million and I have $1 million. But then we do all these investments, and we have $3 more million. So now we have a total of $6 million. 3 of that is community property, right? 2 of it's still hers and 1 of it's still mine. So we can back out. We can trace that through. We can trace that mixed property through there. It gets really convoluted, particularly when you've been married for 10, 15, 20, 30 years. One of the things that people don't think about is my 401k. That's mine, right? Because I worked for it and I put my money into it. Your 401k is community property. It belongs half to you and half to your spouse. Ooh, I see, yeah. Didn't think about that one, did you? That is certainly one that we have to, your IRA is the same way. So your investments, all those different things, the court is going to look at everything to see how to divide it up in a just and right division. That's the magic term, just and right. All right.
I have another question.
Yes, ma'am.
So, what is the purpose of people doing prenuptial agreements? If what you own prior to the marriage belongs to you, I guess I don't quite understand.
What's the purpose of
states where?
What's the purpose of prenuptial agreements? Why would someone do that?
Right.
Okay. Well, let's just say that I'm going into a marriage and I have $1 million. My wife does not. And my $1 million came from my family, okay, or from what I've done, and then but it's mine. And I get married, well, what if I get divorced? Okay, and people think about that. Well, what if something happened? And it's not really just about, well, what if I get divorced, but it's, what if that person dies? Then who gets it? Does her family get it? It's a way of protecting what I go into the marriage with. I'm not saying whether it's principally right or wrong doing it. There are reasons to do it, and there are reasons that are just, you're being greedy. There is a philosophy which I still hold to, the base philosophy that if we're going to get married, then what's mine is yours and what's yours is mine. Okay. However, in today's society, when we have a lot of fraud, we don't know necessarily what we see is what we're going to get. We might want to protect that going into it. I'll tell you where it really comes into play, though, is let's just say that you have a widow and a widower, and one of them might have received a fair amount, or maybe both received a fair amount of life insurance money, and you want to preserve that for your children. The best way to do that is to have a prenuptial agreement so that your separate property, all the money that you've got, which really you intend to go for your children, but children can't really own property in the state of Texas. So it's the parent that owns it, not the children. So you want to protect that so that your spouse can never take that away. It'll always go to your children. Does that help answer that? So there are reasons to do it. A lot of people just do it willy-nilly. Did you have a more specific question about that, or?
No,
Okay.
I was just wondering why they need it if the property you already own, when you go into the marriage, is yours. Why is that additional document needed?
If you have children from a different marriage and you're a blended family, then it really does help doing estate planning. In the event that somebody doesn't have a will, that really helps. There are reasons to do it, and they're very valid reasons to do it. Sometimes not so much, but there are definitely valid reasons to getting a prenuptial agreement. It does help with the division of property. Yes, sir?
Is that other option that your scenario is speaking of, the other option is to have a trust, everything will go to your children? What do you do there?
Well, the question is an option to have a trust and have all your separate property in a trust, then so that could go to your children. That is certainly one way to look at it and do it. Yes. You're talking about some estate planning issues there, which you would just need to look at. But that is certainly one possibility you could look at doing that. Yes. So you're just trying to set up some vehicle to make sure that you're not commingling separate property with community property. All right, so now we can get a divorce and we can get the dissolution of our marriage because either the judge found fault or didn't find fault, or there was criminality or something. And we've divided the things. We've divided the chair. Now we're going to go to the division of the children. And this is the one that is in court most of the time. And you can imagine why. Children pull at our heartstrings, right? And this is where family comes in and says, you can't let her do that. You can't let her get away with this, man. You got to stand up and you got to do that. Or you have somebody counseling the wife and saying, oh, you got to take him to court. You just can't let him do this. So it's the division of the children. And I know that sounds crude, but it is. We're not cutting the baby in half, but we are cutting time, either in half or 43% to 57%, or somewhere around in there. You know, out of 356 days, one parent might have 160 days, and the other one have 200 days. So whatever we'd get to 365 days, it's rarely 50-50. Even if you have a 50-50 parenting plan, you know, just if you look at the end of the year and you calculate the number of days that would actually be, I would be aghast if you found anybody who had an actual 50-50, 182 and a half days. All right? It just hardly ever happens. So we have these things called a standard possession order, right? Standard possession order is what, if you take the love out of it, our Texas Family Code says, then you get the first, third, and fifth weekends from Friday to Sunday night. And you get every Thursday. And then in the summertime, you get 30 days. At Christmas, we're going to alternate. At Thanksgiving, we're going to alternate. So they try to pan out things. And a standard possession order gives one parent about 55%, gives the other one about 45%. That's what happens in most cases. In the last 10 years, there's been kind of a circle around doing 50-50, like week on, week off, or Saturday, Sunday, Tuesday, Wednesday, and then you flip the next 3 days or whatever it is. So Thursday, Friday, Saturday would be with you alternating. So there are different ways to do 50-50 schedules. So you're gonna look at time. So some of the things that we're looking at then is support. Who's going to support the kid? The judge is going to look at both parents to see, well, how much money is it? The judge is going to award child support somehow. Or maybe both parents have enough and the judge says, no child support. Y'all are going to split 50-50. Then you take care of the kid, you take care of the kid. Y'all make roughly the same, whatever it is. It's all over the place. There is no standard thing. However, the standard child support is 20% for the first kid and then 5% for every child after that. So if it's 20%, if you have 3 kids, then it would be 30% because it would be 20 plus 5 plus 5, so you have 30% of the other person's net available resources, kind of their gross take-home pay. Okay. So in the division of children, whose kid is it anyway? Is it a kid of the marriage? Or is it a kid outside the marriage? What if it doesn't belong to the father, to the husband in the marriage? Well, then you can challenge that on paternity. We have a presumption in the state of Texas that if you're married and the wife has a kid, that's your baby. That's the husband's baby too. Unless you challenge it, that's the way it's going to be. You only have a little bit of time, maybe a couple of years to challenge paternity on that. Maybe not even that long. Judge might hold you accountable if you didn't bring it up then, and you could have. Then you kind of wasted your opportunity to say, hey, that wasn't my child. Paternity, then surrogacy. One of the things that we have that has really popped up lately in the last 10, 15, 20 years is surrogacy. We have other people having other people's kids. So how does that play into it? A court has to figure that out. Well, whose kid is it? Maybe the wife is having the child for her sister or her brother or someone else. Then we've got to figure those things out. Sometimes it's not so easy to figure out because the presumptions have always been, and the presumption is in the state of Texas, if you get pregnant and you have a baby, then it's your kid. Even with surrogacy, it might not even be the woman's kid. Think about that. Because that's really not until recently that you could put in a fertilized embryo into another woman and have a child that's not biologically that mother's, the one who delivered it. And so we have these things are getting challenged all the time. We're going to have genetically challenged kids, right? And we're going to have challenges for genetics of test tube babies or whatever else when some of these things get going. It really is becoming more difficult to do when you apply it to divorces and to families. And then custody, which I was just talking about, which has to do with standard time or possession, access, and your rights and duties. So the rights and duties that we have that we really fight over are those about, well, who gets to designate the primary residence of the child? Sometimes we call that the primary parent then, right? If you give that, then there's a good chance that the other parent then just gets the standard possession order. and you have the superior right of designating where that child lives and goes to school. So there are the rights about education, about medical, about how you treat a child. Who's going to have the say-so of which pediatrician you go to? See, some things you just don't think about. And the Texas Family Code doesn't care anything about love in this. It is about what is going to be the most useful way to get through this, the most beneficial way to get through this, so that we're not back in court all the time, and the kid has a chance of being raised in a manner so hopefully they won't repeat the same things. Yes, ma'am.
I have a question. Well, this is grandparents' rights. I was listening to you. I'm raising my 9-year-old grandson.
Okay.
Okay, his mom is out of the state. I haven't seen my child, my son in a while. And I found out the paper that she signed for me to get him in school because he lives with me. And I went to talk to one attorney about it. They said she just gave me rights to, I was thinking she was giving me custody to
Okay.
keep him so I could raise him. And they said she gave me custody for school and that she could come anytime and take him from me.
Okay, so I hear you. So what, and I'm not going to answer anybody's specific questions, in terms of if it really applies to you. This is about someone else.
Oh,
But what I hear you asking about is, as a grandparent, having a school-age child that you're essentially raising in your house. You're probably putting clothes on the child's back, feeding the child, doing all those things as the parent, because the parents aren't anywhere to be found. And that happens. And so, what rights do you have? That's an excellent question. You don't have any rights. Okay. We can do certain powers of attorney. So a parent can say, I'm going to allow you to take care of my child and treat my child if my child needs to go to the hospital, gets hurt, whatever else. But the rights and duties, you're kind of just naturally assuming. There is no written thing there. There might be something you say that she gave you some written document, okay? And I don't know what it is, but there are certain things that we can do, certain granting of rights or powers of attorney to be able to watch my child, to take care of my child, to enroll my child in school. But they can be challenged. Those things can be challenged at any time by the other parent.
but for his safety, and now do their proof, how would I go about it?
I can't answer that. How would you go about getting that done? There are different ways to do it. And if you'll keep that thought, maybe it'll help as we kind of go through this a little bit more. And I'll try to think about that too, about how do you do that? There are ways. I just don't want to blurt out things because I don't know everything about your situation. But keep that thought, and we'll kind of come back to it a little bit. Other things that affect the division of the children is abuse. And boy, let's think about that and how often that occurs. CPS steps in because that child has been abused, and a teacher or a doctor or someone else, somebody called and rescued that child from an abusive situation. Now I'm going to go ahead and say this. Sometimes CPS steps in when CPS really shouldn't, and I wish that they wouldn't. Sometimes they don't step in when I wish they would. We all have that frustration. But and I'm going to go ahead and skip to the other one too. The last thing there is adoption. Okay, adoption comes out of the parent-child relationship, right? So if you have adoption, the first thing in an adoption that has to occur is a termination of rights of the natural parent. Okay? That's not easy to do. I had the pleasure of doing an adoption last Friday, the Friday right before Mother's Day, because I had this family who was fostering a child for about a year. Child was born with marijuana in the bloodstream. Mom had marijuana in her system and other things. And so the parents never stepped up to the plate. CPS did step in, and they gave them every opportunity to be able to turn their lives around and do something to show that they were worthy of being able to raise that child. And they couldn't. They didn't. So I got to represent the parents in the adoption of that. It was glorious. And it's just so cool to see an adoptive mother there crying in court, nearly like a mother would be crying giving birth in the hospital when she's holding that little baby and they're taking it in as their own. So adoption comes out of this. Abuse comes out of this and is dealt with. And if you're found to be the abuser, man, there are a lot of hurdles to get over. And a lot of people can't meet those hurdles. There are programs out there and there are things like that, but there are many hurdles to go through if abuse is part of your divorce case and you have children. So, this last part here, if you look to see how this is severed, we now have a lot of people who are not married having kids. So, all the other stuff we talked about, the divorce, and community property, and all those things, doesn't matter. Now, a lot of what we call original suits are brought up under what's called a suit affecting the parent-child relationship. SAPSR. That sounds cool, doesn't it? Suit affecting the parent-child relationship. And that's what's going to be the case that determines whether dad has rights, mom has rights, who has superior rights, who gets possession, when and how, who's going to pay money, when and how. So those are the suits affecting the parent-child relationship. If you see that divorce really isn't on the rise, and it hasn't been for a long time, think about this. SAPSRs have risen dramatically over the years because we have so many people not getting married. They're not bothering with the first part. But the suit affecting the parent-child relationship really came out of the marriage side under the family law. Okay? Now we just have special sections that you can just skip right to the suit affecting the parent-child relationship and not have to worry about the divorce or anything else. One interesting fact, and I'm going to open it up for questions. So, is that in a marriage, and we have the Texas Family Code that says of union between a man and a woman, and theoretically then you're supposed to get a license and get married in front of someone who has the authority to sign it, a judge, a pastor, certain officers in military might be able to do it. But we also have this thing called common law marriage. Anybody heard of common law marriage? How do you get a common law marriage? How do you establish it? Do you know what do you have to do to be common law married? So many years together. What else? Introduce yourself as husband and wife. Okay, great. So here's the little trick. It takes 3 things to be common law married in the state of Texas. Again, this is just the state of Texas. You have to intend to be married. How do you do that? You have to hold yourself out to someone and say, yeah, this is my wife. This is my husband. And not challenge that. You know, you've heard people say, oh, this is my wife. Well, no, we're not married. We're not married. You know, they're saying, no, we're not common law married then. You have to hold yourself out to be husband and wife. Sign into a hotel together, right? File taxes as married, joint, right? And then you have to live together, cohabitate. For years? can be one day. It doesn't know. There is no time limit. So think about that. Think about that when someone's moving in with someone. And your kid's moving in with someone, oh man, it's harmless, we're just gonna live together for a while. Really? Okay. Well, be careful, because you've already probably told them you're playing with fire if you do that. And you really are playing with fire, because it only takes those three things to be able to say you're common law married. Okay? And we prove those things, prove intent, because you find out, how did you hold yourself out to be husband and wife? Oh, we went to all these things, and I said, well, that's my old lady, that's my man, that's right, we're married. We filed taxes together, we went to the doctor together, we did whatever. So it's easier to get common law married than you think. It doesn't take 6 months, doesn't take a year, doesn't take any time at all. There is no time specified. Think about that. With that, let me talk quickly about, do you go to trial, or are there ways still to try to resolve these and put some of the love back in and try to resolve these things without going to court? You go to court, go to trial, you're relying on someone you don't know and doesn't care about you and doesn't care about the love in that to say, this is how it's going to be. Collaborative. My favorite. Collaborative law. We take the husband and wife come together, each have an attorney, and then we have a financial professional, like an accountant or a financial planner, someone who knows how to deal with divorce assets. And then we also have a counselor or a social worker, someone who helps be a communication coach. If you have children, they can help work out a parenting plan that is going to hopefully be much better than just the standard possession order, just whatever it's going to be. So there are ways to do that. You do that without ever having to go to court. It can really, really work well. I've even had it so that people have reunified and collaborated. Arbitration or private judging, you can still keep things out of court. You could ask for a lawyer or pastor maybe to be a private judge and get the court to approve that. Or a panel. I've seen churches who have put panels together. I don't always like all of them that some of the churches do, but there are some that put together, and it's like they're really trying to be caring about it, and they will listen and try to help you work through that with. Sometimes that's a really good result. Not always, but sometimes. Mediation. Mediation occurs when you get, before you go to trial, just about every judge is going to make you go mediate. Okay, you get in front of a mediator, and that mediator tries to help facilitate and bring out the good things and try to see where you can meld those together and come out with an agreement in like a day or so, where it's much more palatable to say yes to that, say yes to the dress, than go into the trial. Does that make sense? Okay. What questions do you have? I'll try to answer them. I can't answer all questions, but I'll certainly try to. Yes, ma'am.
Okay, so as far as like grandparents' rights, say the child and the mother live in one county that has no grandparents' rights, and then the grandparent lives in another county who has grandparents' rights, at what point do the counties kind of take over and say like they can't because the mother and child live in a county that has no grandparents' rights?
Okay, so back on grandparents' rights. So let me kind of rephrase what I mean by that. When I mean grandparents having standing to be able to file their own case to try to get that child.
Or like even visitation. So like say said party doesn't want the grandparent to see or have visitation or things like that. Like how do they?
Where are the mother and father?
In one county.
No, I mean, if there is a parent there, that parent can bring the suit. And then they can involve the grandparent and ask for the grandparent. If the grandparent has been a caretaker and those things, it's just that a grandparent can't just file the lawsuit generally. That has been corrected over the last couple of years a little bit, and I think this last legislative session may help clarify some of that grandparents can step into the shoes and file file the lawsuit to say, hey, I want custody, or I want those rights and duties.
You're talking about custody, not visitation.
Well, okay, so
I'm
custody,
talking about like visitation.
okay, so there's custody, which means what?
Just taking the child and raising them and having full custody.
Okay, so if you have let's say that you have a mother and a father, is there no father at all?
I mean, yeah, but, okay, so the situation is, I don't want my father to see my child. And so I don't want him to be able to file for visitation rights with my child.
Okay, and let's not make this about you so much, but,
This
but,
situation.
but I hear what you're saying. Okay, so a parent still exists to bring the lawsuit. And every one of these is a lawsuit. A divorce is a lawsuit. The suit affecting the parent-child relation is a lawsuit. The division of property is a lawsuit. And so, as long as the parent is still involved, that parent can do that. Now, can a grandparent jump in there and file something? That's difficult. That's still a slippery thing there. And it really just depends on the situation. There is no guarantee of one way or I can't really tell you without knowing all the facts, and I don't want to know all the facts in front of everybody. And then it's an attorney-client relationship, and then I've shared it with everybody, so. And so I've got to keep some things confidential, so. You would just need to find out about all those, what's going to happen. If the grandparents I bring that up because just traditionally grandparents have not been able to step in and have a say-so or be part of it. In Denton County.
Okay.
In Collin County, they would.
I see
You know,
this.
judges would say, yep, go ahead and come on in, we're gonna pull up a chair. You're gonna be part of it.
Okay. And then, a good place to look into that would be on like the Texas Gov website.
A good place to look into that would be to consult with an attorney. There is nothing better than consulting with an attorney on those things. And it's not just a profession protection thing.
Yeah, definitely.
If you go to look to interpret the code and how to do those things, then you're practicing law for yourself.
Yeah.
You take out your own appendix. You don't practice medicine on yourself. You may put a Band-Aid on something, you may do something, but you're talking about a serious thing now that really is kind of invasive into your relationship. And I really would recommend that you get someone who is qualified to do that. Sir?
Forgive me if you ask these, but sometimes in the ministry I get these two questions, both in the case of a divorce or maybe like a SAPSA, right? So the first is the limitation on residence, so, they used to draft about, this town,
Yes.
county, and contiguous ones.
Uh-huh.
Right, I want to talk, so you could discuss that. And then the second is modifications, particularly on child support. Somebody will get a suit about that, and, she wants more money, or he doesn't want to pay, whatever. Could you address those?
Sure. So the two things you're asking about, let me start with the first one, which is asking about what we call geographic restrictions. So when we're back at the division of children, it is very common that a judge will put in place, if you have two parents who are a mother and a father of the child who are wanting to be part of that child's life, then most of our judges in just about all of our counties around here will put in place what's called a geographic restriction. The default geographic restriction is the county that you're in and all of the counties that touch it. So if we're in Denton County, then you'd have Tarrant County and Wise County and Cook County and Collin County and Dallas County. Sometimes you might even get a judge because we're like in a metroplex of, it may take longer to get to DeSoto than it would take to get to Seymour. And that's not fair, right? So some judges may say, not Dallas County, or not past 635, or not past a certain point, so that it's not unfair to a parent who lives over here. Because a lot of times what'll happen is, oh good, I'm just gonna pick up and I'm gonna move to the other side of that county. If we're here in Corinth, and I'm gonna pick up and I'm gonna move all the way over to Princeton or someplace, you know, in East Collin County, you're gonna have to drive to come pick up the kid. Well, that's not fair. And most judges will say, no. We're gonna put a geographic restriction in there that's reasonable, particularly given traffic and given time of day and whatever your work situation is and things like that. The second part of your, the second question you had was about modification of child support. Let's say that you have a 2-year-old child, you go in there, you get a divorce, or let's just say you weren't married and you have a SAPSR, and the court sets, and let's just say that I'm working at Walmart and I'm making $15 an hour at Walmart, and the judge sets my child support at $350 a month. And then that kid is 2 years old, then the kid turns 10 years old, that's 8 years later, and I'm an executive with UPS all of a sudden. You know, over the last 8 years, I went to school, I got all this stuff, and now I'm making, you know, $200,000 a year. Then you can go back to court and ask for a modification of child support. Now that's drastic, right? Going from $15 an hour, from making about $30-some thousand a year to making $200,000 a year. But that's over 8 years. Usually it's gradual over the time. So the courts don't want you back in there really until every 3 years. So they don't. So there's kind of a general rule of thumb. The language is actually if there's substantial change in circumstances. If there's a substantial change in circumstances, then you can go back to court. So if Papa hits the lottery and then all of a sudden, you know, bought a business and he's making, you know, $500,000 a year from 1 year to the next, then yes, take him back. That's a huge change in circumstances. That can count. So that happens. The courts don't like you back in there very often. So they've been really trying to put it so that, you know, look, 3 years or $100 a month more. If it's not going to be more than $100 a month more, don't bother coming back here. And I think that this legislative session, we're going to be seeing some stuff go into the Texas Family Code that really makes that more real, because they don't want, we keep getting more district courts. The most cases that we get are family law cases. Every one of our district judges here in Denton County handles family cases. And that's the way it is in a lot of counties. Dallas, they have it separated out because they have family court, they have criminal court, and then they have civil court. So some counties are starting to parse out so that family is its own court section. It's a big deal. Because we have, so they're trying to limit some of that, trying to say, no, you can't go back modified just for $25 more a month. Any other questions? Yes, ma'am, in the back.
Okay, so if the primary parent says to the non-primary parent, take the child, you know, do whatever, they don't sign power of attorney or anything like that, and the child is with the non-primary parent for 3 years, enrolled in school, all that, how would the non-primary parent go about becoming the primary parent?
Good question. So in other words, let's talk about, and it has to do the same thing with modification of child support. You're talking about modifying possession and access and rights and duties. So over the course of, if your child is 2 years old when you get a divorce, you've got 16 more years of that kid being under the court's say-so of who gets the right to do what. So you can go back and ask if circumstances change substantially to a point where, you know, it would make more sense that I keep the kid more, I get the kid after school more, I'm doing more, the other parent got married or whatever, or just isn't paying as much attention to the kid. It happened. It could happen for a number of reasons. Then you can go ask the court to change it, to modify it. And they'll modify the suit affecting the parent-child relationship. Does that make sense? Does that answer your question? All right. Any other questions? I'll be glad to answer questions as long as the Reverend's not going to kick us out. Say again? Alimony? Bite your tongue. Alimony, okay. So alimony, we're back up to the division of property. Remember? So that's part of the division of property. Before 1991, Texas didn't have alimony, and it still didn't have alimony until just, I don't know, maybe 20 years ago, 1999, 2001. We still never called it alimony. We called it contractual maintenance support. So in Texas, we've had spousal support, which a judge could order, but only if you jumped through the hoops. You showed that if when you got married, that husband went to college, went to medical school, came out of medical school, started practicing, and you had to stay home with the kids, and he made you stay home with the kids, and so you could never get a job. When you get a divorce 20 years later, you're left not being able to make much money, and he's making $300,000-$400,000 a year. There needs to be some evening out there, right? Texas did not recognize alimony, or what we call contractual support, until just 15, 20 years ago. Kind of did, but not really. Just until recently do we have alimony. And the IRS has kind of helped put that in place. The difference between the spousal support and the contractual alimony was who pays the taxes. And I know it's kind of a fine line separation thing, but also the most that a judge would be able to order 20 years ago would have been 3 years maximum, 36 months. And that would be hard pressed to get 36 months of alimony, of spousal support. Now it is something that a judge can consider here, just like they would almost as if they were in other states. Some other states have mandatory alimony. They synthesize what the husband makes with what the wife makes, and then if there's a difference, then they kind of divide that by 2, and you pay the difference to the spouse for 3 years, 5 years, whatever would seem to be reasonable. Every state is different on that. Did that answer your question? I know it's kind of a convoluted answer, but yes, ma'am?
Yes, I have another question. Is there an age where the judge would listen to the child if the child?
It's a great question. Does a judge listen to a child at a certain age as to who I want to live with or who I want to go do with what? Yes, there is a statutory age that a child can voice his or her, say that I want to voice my opinion. It's age 12. Okay. Judge doesn't have to listen to him though. Judge can, listen to him, but probably gives them very little weight. I've had it so that a judge listens to the kid really a lot. I've had it where the judge doesn't listen very much. I've had, if you have a fairly mature 12 or 13-year-old and a judge visits with that kid, and I had this happen just a year ago. The judge had the social worker come in and they listened to the judge together, no court reporter, and the judge asked the kid questions. What do you do over at mom's? What do you do over at dad's? Which meals do you like better, over at dad's or over at mom's? Where do you feel like you do better at? How are your grades? Do you have friends at mom's house? Do you have friends at dad? Do you have 2 sets of friends? And a lot of times the answer to these things is, well, no, most of my friends are at school or whatever. And I do have some over there and some over here. The judge will listen to those things to help determine. But it's just one of the things the judge will look at.